First, I want to say thank you for inviting me here. I am an unabashed constitutional law geek. I love thinking about it and talking about it, and mostly because it creates all sorts of interesting conversations about who we are as a nation, or who we think we are as a nation. And I think that's one of the most important questions we could be asking in terms of civics and generational evolution. And so I'm really glad to be here and be hearing all of you ask questions and the other panelists. I'm going to be picking up where the judge left off and talking about privacy specifically. It's a buzzword in our contemporary society, but it's always actually been at the core of our Constitution and the processes of constitutional decision making. There are many people who think that it was the impetus behind the Bill of Rights, the first 10 amendments. And in 1890, there was an article written by Louis Brandeis and Sam Warren called On Privacy. And so this is from 1890. Instantaneous photographs and newspapers enterprises have invaded the sacred precincts of private and domestic life, and numerous mechanical devices threaten to make good the prediction that what is whispered in the closet shall be proclaimed from the housetops. So this concern from 120 years ago is not gone today, obviously. It is at the root of much of the debate about searches and data privacy and personal privacy. And I'm going to try to sketch out a little bit of that debate, actually to tease it apart and see how the Supreme Court interprets the Constitution differently based on what kind of privacy we're talking about. So generally, there are described to be three forms of privacy. Privacy is nowhere mentioned in the Constitution, by the way. I should say that. It's one of those things that we think we have a right to, but it's not actually literally there, as in how old the president has to be or that women have the right to vote, for example. So it's something we must interpret in the Constitution, and it's an example of implied meaning in our Constitution. We must embrace the implication of meaning in the Constitution, or privacy in all of its complexity doesn't actually exist for us as a right. So there are these three dimensions. We talk about one being bodily privacy, sometimes called bodily autonomy, and that is related very closely to decisions regarding our body. Then there's spatial privacy, privacy about where we are and how the boundaries we can put up between ourselves and the rest of the world or the community. And then there's data or informational privacy, that is private information about ourselves that we want to keep from the rest of the world or the rest of our community. The first category of bodily autonomy or bodily privacy concerns issues generally around forced medical treatment and other bodily intrusive things like reproductive choices. So, for example, in the 1940s, a case called Skinner versus Oklahoma, the court held unconstitutional the forced sterilization as a punishment for a crime. Griswold versus Connecticut, which was in the 60s, that evolved into saying that it was unconstitutional to criminalize the use of contraception. And what tied those two things together was a right to choose whether you would be a parent or not, whether you would or would not be a parent. And so that connects bodily autonomy with decisional autonomy. Now, over the course of the years, those bodily issues have morphed into whether to refuse medical treatment, as I said, the debate currently about dying with dignity, choosing to withdraw medical treatment, for example, and of course the right about whether or not women have the right to terminate non-viable pregnancies is also part of this debate. So where we go from one sort of right to refuse unwanted medical treatment, it expands into all sorts of bodily rights around major decisions, life and death, in our in our life. There was a recent case that I'll just mention briefly that pulls into this theme, and it was called the Florence Board of Chosen Freeholders. And that case actually retreats from a right of bodily autonomy. It's about a strip search in a jail. It's actually a remarkable case. The court decided it last year, where the question was in that case whether if you're arrested, even falsely arrested, and put into a general population in jail, whether you can be strip searched as part of that temporary detention. And the court said, yes, you can be strip searched if you're going to be put in temporary detention. And what made that case remarkable is the person who was being put in temporary detention was being pulled over for a traffic violation, and the state law at issue just said you have to put him in general detention, that you strip search as part of general detention for safety reasons, and it doesn't matter whether there's probable cause or to find you dangerous or not. So the issue of being free from intrusions like that was reduced, people say, in that case. Privacy rights, the right, however we define it, is often up against a countervailing interest. So in that case, the bodily right was up against issues of safety. We're going to see that in the Fourth Amendment context as well. So that there's also the spatial right to privacy, and as the judge mentioned, your home is your castle. The home is where you have most privacy, or at least that's what has always been the case in constitutional jurisprudence. And it is extended at some part to your car as well. You have the right not to be searched unreasonably in your home and sometimes also in your car. The U.S. versus Jones case puts pressure on what a search is. And is the physical trespass what constitutes the search? Or is it this 24/7 electronic surveillance, which is unreasonable? And he described well the court actually breaking apart as to where our reasonable expectations of privacy lie. That is it a spatial thing, do not come into my car? Or is it more of an amorphous, don't watch me all the time, everything that I do? And this whole issue of electronic surveillance, as he said, is going to come to the fore, with GPSs automatically being in our car, our Google Maps, or our Android all of our maps on our devices. And I think it might turn out breaking along a very literal view of space, that is our home, versus something else. And the reason I think that is there was a case just argued 2 weeks ago called Jardinus versus Florida, which is about dog sniffing, a very low-tech kind of search, but it was at the threshold of a house. So the police brought a dog to the threshold, and the dog could sniff what was going on inside. And where previously heat detecting equipment from the outside that detected what was going on inside was an invasive search of the house, doing that kind of thing, dog sniffing maybe in an airport or on the side of a road, was not invasive. I'm going to bet that the court is going to say that the dog sniffing at the threshold of the house is an unreasonable search without a warrant, because the home is such a protected space and symbolic in many ways of what it means to have privacy. So the last form of privacy is what I talked about as informational privacy, which this 1890 quote brings us back to. And here I'm not sure how the cases are going to come out, but I'll tell you where they have gone. Generally speaking, with information privacy, the countervailing interest is the First Amendment, the freedom to know truthful information and to disseminate truthful information. And so what the court has generally been is very unprotective of individual informational privacy as compared to public speech rights. So speaking truth about someone, even if it's a nasty truth, is not going to subject you to defamation liability, for example. Likewise, false statements about you without proof of actual injury to your reputation will not subject you to liability. The First Amendment protects that. So public debate, as we heard in the first panel, overrides the interest of informational privacy, keeping things about yourself private. And that was decided pretty, well, it was a split decision, but I predict this is the way it's going to go in the future. The court decided a case called FCC versus Cooper, I think it was last term, if not the term before, and that was actually about a federal law. As the judge said, these things might have to be protected by law or state law or federal law rather than the Constitution. That was about a 1974 law called the Privacy Act, actually, that managed, it was a rules managing confidential records in the executive branch. And that law basically says that if the executive branch mishandles confidential information about an individual, that individual can sue for damages. And the case concerned a pilot who was regulated by the Federal Aviation Administration. His license was up for renewal, and he did not disclose his HIV positive status to the FAA. But he did disclose it to the Social Security Administration Board. And the SSA shared that information with the FAA, and that sharing of information led him to lose his job. And he said also that it created humiliation, embarrassment, and anguish, and severe emotional distress. And the question the court had to wrestle with was, what kind of damages is he entitled to because of that distress? The court said that actual damages would be required to be shown, that is real pecuniary loss for that sharing of confidential information, and because he couldn't show that, he would get nothing. The dissent, it was 3 judges dissenting, but one was recused, said that that this guts the statute, that the Privacy Act must protect this kind of harm, and they said that otherwise it cripples the Act's core purpose of redressing and deterring violation of privacy interests. The intangible harms to the individual is what the Privacy Act was supposed to protect, the intangible harms, not the pecuniary losses. Requiring proof of monetary loss, they say, guts the statute and undervalues informational privacy, especially against government invasion. Now, where this is going to break out is when we disclose our confidential information every day when we do a search online. That information is given to big data. It's given to Google, it's given to Yahoo, it's given to Microsoft. When we type in something on our phone and it stores that information, and Verizon or AT&T or whoever it is collects that data, are we waiving our rights to that informational privacy about that information when we give it to a third party, such that it is free to be shared, so we don't have a reasonable expectation of privacy in that information? The way we waive it when we drive around in a car in public and the police can tail us, that's not a violation of privacy. They cannot go into our house without a search. Which is it? When we search online, is that privacy that is protected from a search without a warrant? Or is it like going out in public and doing things that can be viewed? So far, the court has suggested that even private information we share, like where we withhold, like this pilot, is not as protected as other forms of privacy because he's not getting fully compensated for the injuries. And I'm going to guess that the court is probably, at least initially, going to say government intrusions on data might be held to a higher standard. But when we give that data to a third party, even, for example, in a Google search, that may be a form of waiver and diminish our privacy because our reasonable expectations are evolving with the times, and privacy is measured in part by what we do and what we expect. So if you're keeping count, spatial privacy is very strong in our home. We remain, the home is our castle. Bodily autonomy, there's still a lot of debate about what kind of control we have over our body. We can refuse medical treatment, but we might not be able to allow ourselves to die or choose to die. The right to terminate pregnancy obviously is still hotly debated, although enshrined in a case and many other cases. And data privacy, I'd say, is really low on the list right now. Informational privacy about ourselves, in part because of the strength of the First Amendment. Really interesting stuff, and I look forward to hearing your thoughts on it.